Any mention? May it please, Your Lordship, I would like to mention item number 14, Your Lordship. In this matter, Your Lordship, in the last occasion, the respondent number 1 to 3 are supposed to call for records, Your Lordship.
Well, records have arrived. We can have the hearing next week or after 2 weeks.
Your Lordship.
Records are available.
We're asking for adjournment, isn't it?
I pray that the matter may come up
Just
after
for the
2
records
weeks.
and all, you can take it up where it comes. But then, if we're asking for adjournment, okay, then we can pass an order.
Lordship, I'm appearing for respondent 4 and 5.
Okay. Therefore, respondent 4 and 5. Therefore, 1, 2, 3.
1, 2, and 3.
And you are asking for time.
Yes, Your Lordship.
When do you want it?
I pray that the matter may come 2 weeks, after 2 weeks, Your Lordship.
Item number 14. United Counsel for the petitioner. Case for grant of 2 weeks' time. Matter stands adjourned. Prayer allowed, matter stands adjourned.
Obliged. May it please, Your Lordship. Lordship, I beg to mention item 9, my Lord.
1 second, Mr. Dev.
Item 9, Lordship. Here, my Lord, it's a knockmanship dispute. Lordship was the counsel.
Can I?
Yes, Your Lordship, if I may press Your Lordship, that Your Lordship was one of the counsel.
Reach this matter before any other bench without me.
Are you obliged?
Please, Your Lordship, I beg to mention item number 9.
Item number?
Number 5.
Number 5. Yes.
Lordship, I'm praying that this matter may come after 2 weeks.
This 2017 matter you are appearing for?
For the petitioner.
2017 matter, madam.
Lordship, I seek your recommendation for today since the conducting counsel is out of station.
Your Lordship, appearing for 1, 2, 3, and 6.
Where is Minta Kinta?
Your Lordship, they've already informed us in the morning, Your Lordship, so.
Lordship, I'm appearing for respondent
See,
7,
there is. Yes.
7 and 8, Lordship. Respondent 7 and 8.
7, 8.
7 and 8.
You record the name who appears for. See, these are old matters actually, you see.
Yes, sir.
And we have quite good numbers of old matters which requires disposal.
Yes, Your Lordship.
Please be mindful of the thing.
Yes, Your Lordship.
Okay, as prayed for by the counsel for the petitioner. This is matter after 2 weeks.
Much obliged, Lordship. Your Lordship, similar prayer for item number 10.
Item number 10.
Union of India. No? 1, 2, 3.
Yes. What is this matter about?
It's a service matter, Your Lordship. Where the
Dismissal.
Assam Rifle. No?
You asked for time.
yes, Your Lordship.
Assam Rifle. No?
Yes, Mr. Sulai.
Lordship, the state in this matter has a very limited role. The main contesting respondent is the school money committee.
Nobody is appearing for the school managing committee.
This is
Have they appeared? Whether service was affected or not?
Hillview Secondary School.
Lordship, I'm praying that this matter may come after 1 week.
No, we must first, you see, verify the fact whether all the respondents have been served or not. Though many names of many councils are appearing on the cause list. We should be sure of that.
It's a 2019.
Your Lordship, respondent 4, 5, 7, and 8, they have filed their affidavit in opposition.
Okay. 1, 2, 3, I think, are state.
State is not
Okay, filed affidavit. And then,
necessary.
so it means they entered appearance.
Most probably, Your Lordship.
Okay.
If they have filed the affidavit, then certainly.
MS so and so, counseling applicant for the petitioner. 6. Praise for grant of 2 weeks time. The prayer has not been opposed by the respondents. Accordingly, this matter after 2 weeks. After 2 weeks.
Duly obliged, Your Lordship.
Apply, Your Lordship.
Please, Your Lordship. Lordship, I beg to make a mention on item number 4.
Item number 4.
Yes, Your Lordship.
These are old matters, Mr. Yes, this is Nakma matter.
Yes, Your Lordship.
Don't want to do it.
Your Lordship, Mr. Paul is leading us in this matter, Your Lordship. Mr. Paul is leading us in this matter, Your Lordship.
I couldn't follow Mr. Paul.
Mr. Paul.
Yeah.
Yes, Your Lordship.
So when will he be available?
After 2 weeks, Your Lordship.
See, this is pending matter from 2017.
Lord, can we?
This is one problem. You see, like you have to keep it in mind when you mention next time.
Can we grant 2 more weeks, Your Lordship?
A mention has been made for adjournment on the ground that Mr. K. Pollander, Senior Counsel, is indisposed. Not
Objection.
the prayer has not been opposed by the counsel appearing for the respondents. Accordingly, matters stand adjourned to 2 weeks.
Lordship, similar prayer for item 15, Your Lordship.
What?
Item 15.
Item 15.
Yes, Your Lordship.
My lord, this is a MBCL matter, and this matter is a fixed matter, my lord.
It's a fixed matter.
My lord, yes. And I appear here in this matter for the respondent along with Mr. S. Sahai, my lord. And we have been objecting this matter for adjournment for the past few weeks also, my lord.
Yes, Mr. Sahai. They're asking for
Lordship,
time.
Lordship may see the order sheets. In fact, they've been seeking time and again. Some cost may be imposed because these matters, every time the corporation is being compelled to appear, these are otherwise not.
What is the matter about?
Lordship, this is a case where a disputed amount of 2014 is being claimed by way of writ proceedings in the year 2020.
You are
So
not audible
apparently,
properly. One second, Mr. Sahai. I cannot hear it. The volume is very low. 1 second, please.
The volume is low.
I do not get the sound. Difficult.
Lordship, am I audible now?
Your voice is very low, Mr. Sahai. I cannot hear it properly.
Lordship, perhaps I'm more audible
Perhaps there
now.
is a problem with the system. May not be your thing. Anyway, so you want to proceed with the hearing today?
Yes.
Yes.
Lordship, 2 more weeks.
Hmm?
2 more weeks, Lordship.
Difficulty. This is really a difficult situation, where councils do not agree.
Lordship may grant them a final opportunity, but Lordship may make it clear in the order.
Last terms.
Lordship.
Okay. A mention has been made on behalf of the petitioner on the ground that Mr. K. Paul, under Senior Counsel, is indisposed. A mention for adjournment, in the beginning, a mention for adjournment has been made. The prayer has been vehemently opposed by Mr. Sai. However, for the ends of justice, the matter is adjourned for 2 weeks. It is made clear that no further adjournment would be allowed. But okay.
Can you oblige, Lordship?
Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 17 on behalf of respondent number 2.
Item number 17.
I am for the petitioner, my lord.
For state, my lord.
The criminal petition.
Criminal petition, my lord, jointly filed by the husband and wife. The state contends that, my lord, this is a case under the POXO Act.
Okay.
The victim says she's above 18. She was above 18 at the time of the offence. And she has documents to show that she was major.
So this court will record a finding that she is above 18 and then...
No, my lord, she is already in a statement under 164 also, she has clearly indicated that she is above. So, my lord, that will amount to an abuse of the process of law, my lord. That is why I have come before under petition under 482, my lord.
You are the husband.
We are the husband and wife.
The husband and wife both are petitioners.
Both of them. She's my father-in-law.
It's a collusive petition.
My lord, the fact is such that, my lord, I am permitted to file this petition.
You could have made your wife as a respondent.
My lord, I could have, but my lord, there is no embargo if I come together, both of them come together also, my lord, because situation is such.
Private respondent. You have no objection to their prayer?
I, my lord, for a week.
A week, yeah.
If it's for a week, I have no objection, my lord.
No objections.
Item 17. A prayer has been made on behalf of the respondent number 2 for adjourning the matter for 2 weeks. For
1 week, my lord. It's a very
week,
small matter actually.
The prayer has not been prayer is not opposed by the Land Council appealing for the petitioner. The matter stands urgent. Listed after 1 week.
Much obliged.
A similar prayer for item number 16, your lordship.
16, who is appearing? P.T. Sangma. Mr. P.T. Sangma is here. Yes, Mr. Sangma.
And for the respondent.
They are scared of you. They are asking for time.
16.
No objection.
No objection.
You are appearing for?
For respondent number 5 to private respondent 5 to 7.
Oh,
So no.
private respondent.
For private respondent.
What is this matter about?
This is, I'm challenging the order of the District and Session Judge William Nagar. What happened actually, FIR has been filed by the petitioner. And then without issuing any so-called notice, the District Session Judge has accepted and passed an order.
No problem with your adjournment.
We are objecting to that, my lord, to the prayer of the petitioner, my lord, because they are asking for.
No, that is okay. I'm talking about the prayer of adjournment today.
No,
Right now
it is for 1 week, my lord. I have no.
1 week time. Okay. Here also, counsel for the respondent number?
5 to 7.
The same order, same kind of order, only just changes. Okay. Just make a prayer for adjournment now.
Much obliged, your lordship. May please, your lordship, I beg to mention item number 7. On behalf of Mr. GM, thank you.
Lordship, item number 7, Lordship, it has been fully heard by Justice Dingdo, Lordship, and all the parties have concluded their argument. So, Lordship is pending for filing of written argument only, Lordship. I have filed my written argument.
Okay.
So it's to file. We are yet to file written argument.
So this is basically a partner matter, is it?
No, it has been fully heard by Justice Dingdo.
So what is to be done then?
Now it's pending only for filing of written argument.
Written argument.
No, what is your prayer then in such a case? You want it to be conducted by this court or you should go before that court? What is your prayer then?
Since it has been fully heard by Justice Dingdo, Lordship, let it go to the Justice Dingdo court.
And then until unless it is kept part heard, can it be done?
Also will go by the roster, not after the
Definitely.
submission made. Go by the roster. Since it's not a parhat matter, so.
Yes.
If your Lordship take up, then the hearing will have to be.
You have to do it afresh.
Rehear.
Okay.
Afresh.
Yes.
So this will be trouble for you, but then again I have to hear it. See, there is no other option. Yes, madam.
Due to medical emergency, Mr. GM, thank you, was not able to be present here today, Lordship. So I'm praying for a week's time.
No objection.
No.
A prayer has been made on behalf of the petitioner. to adjourn the matter for 1 week on medical ground.
Yes, Lordship.
The counsel for the respondent has no objection. Accordingly, the matter stands adjourned, listed after 1 week.
Obliged.
Much obliged.
Please, Lordship. Lordship, I'd like to make a mention for item 6, Lordship. Item 6.
Yes. This is also 2017 matter.
Yes, Lordship. Mr. Police out of station, Lordship. Item number 6. Part heard, Lordship.
Oh, that is regarding the removal of those hoardings and all those things. What remains there now? How many years?
That was based on a Supreme Court direction. It was where complied. Hardly anything involved in that case. But ठीक है ना, we can accommodate. He's not here. He's asked adjournment in other cases.
Problem is with pendency, Mr. Khan. You know very well.
Yes, absolutely.
These are already 6 years old.
Absolutely.
A mention has been made by the counsel for the petitioner on the ground of non-availability of Mr. K. Paul, senior counsel, to adjourn the matter for 2 weeks. 2 weeks. The respondents, Mr. Khan, not 2 weeks, 1 week.
2 weeks, Lordship.
I said 2 weeks. Mr. Khan, Learned AG appearing for the state, has no objection. Accordingly, matter stands adjourned, list accordingly. Matter stands adjourned, list accordingly.
Maintenance item number 1.
May it please, Your Lordship.
Yes, Mr. Lee.
This matter also, my Lord, was in fact concluded before Justice Dingdor. But however,
See, the most of the files which have come here right now, more or less all the same. Some are pending
Anyway, it
for
doesn't
statement and all those things. Only thing is that you have to apprise me of the entire thing again, because I do not know. I have
the short point for consideration in this petition is notice under Section 11 of the Land Acquisition Act. My Lord, my plot of land was acquired way back in 2009. Notice was issued by the Deputy Commissioner under Section 4.
of the old act. Is it 2009 old act?
Yes, old act. Old act.
Give me that.
I have also filed my written submissions. It's already on record since 16/11/2022.
Written submissions are already there.
Yes.
Same, Your Lordship. In our case also, we have filed on it.
You have also.
Yes, citizens.
So I'll just brief Your Lordship. Yes, but it was not kept as part heard
Absolutely.
or CAV, so we have to. It's a very short point.
Well, very short for you, Mr. For me may not be. Huh? Anyway, just let me try to get the.
So, my Lord, in 2009, notice under Section 4, read with Section 17(4). 17(4) is the emergency provision.
One second. One second. Okay.
My Lord, will come to my writ petition. We'll accordingly go by the records there. Page 11.
Yes.
So this is a notification dated 24th November 2009. It is hereby notified that the land with the boundary described below, measuring more or less so-and-so, in the village of Mendipathar in the district East Garo Hills is likely to be needed for the purpose of construction of a new BG railway line from Dudnoi to Mendipathar as per the details of the land acquisition given below. This notification is made under the provisions of Section 4 of the Act of 1894 as amended by Act 68 of 1984 to all whom it may concern. So this is the notification under Section 4. And the next page, Mala,
Section 6.
annexure to page 12. This has been issued in exercise of the powers under 17(4). 17(4), my Lord, is very well aware of the emergency provisions. So on 30th November 2009, this notification was issued. And at page 13, my Lord, is the details of the landholders. And at page 14, my Lord, my name appears, rather my mother's name appears at serial number 56 and 57. Page 14.
Mansila Momin.
Yes. Marsila Momin. Yes.
This is a list of claimants, isn't
Yes,
it?
yes.
Okay.
These are the list of the persons. Then, my Lord, Annexure 3, page 15, is the notice calling for under Section 9 of the Act. Notice is hereby given that on so-and-so date,
square meters more or less of the land situated in the village Mendipathar in district of East Garo Hills described below and recently marked out and measured are about to be taken by the government for construction of the new BG railway line from Dudhnoi to Mendipathar under Act 1 of 1894 in accordance with the declaration published by the Gazette of Meghalaya on so-and-so. All interested persons in this land are hereby called upon to appear personally or by his agent on 1/11/2010 at 11 a.m. to state the nature of their interest in the land and the amount and particulars of their claims, to compensate for the same and their objection, if any, to the measurement made under Section 8 of the Act. That was the notification. Now we'll come to the next page, page 16. This was, of course, another date was fixed because of the ensuing municipal elections. Now look, next page, page 17 is important. This is a letter from the collector to all the concerned landowners and to Srimati Marsila Momin. Payment of 80% of land compensation for acquisition of land for construction of new BG railway line from Dudhnoi to Mendipathar in respect of village one so and so. On approval for payment of 80% as advanced by the Government of Meghalaya in the Revenue and Disaster Management Department, Shillong, by notification dated 27/7/2010, you are hereby directed to attend the office of the undersigned on 22/12/2010 at 11 a.m. onwards in connection with the payment of 80% of the total estimated cost of land compensation for acquisition of land for construction of the new BG railway line from Dudhnoi to Mendipathar in respect of so-and-so. You are also to bring along with you the relevant documents in support of your claim for the above land compensation and produce the same before the undersigned for verification at the time of payment. Now, after receipt of this letter, I, by Annexure 6, page 18, I wrote to the Deputy Commissioner and I have specifically stated here that I will accept the 80% compensation, which has to be paid under Section 17 formula. If you are going to exercise the emergency provisions, you have to pay that 80%. In paragraph 3, I have stated, however, I specifically state that I am willing to accept the 80% on the compensation offered by you under protest, as I do not consider the compensation offered by you adequate and just, neither in relation to the market value of the land proposed to be taken over, nor in respect of the value of latex given under rubber trees standing around. So basically, I have said that I am not satisfied with the award.
It is received
at that point of time, the award has not been passed. Now, 80% is paid on the Act. It is not clear, my lord. Even the Act is not clear. Now, if you are going to give 80%, actually there ought to be an award. An award is the amount fixed by the collector.
Definitely. Otherwise, on what basis 80%?
On what basis do you come to that 80%? Now, my lord, interestingly, page 20, Annexure 7. Now, this was a printed sort of undertaking, which was in the office of the Deputy Commissioner at that point of time. I may read, Your Lordship. I, the undersigned, landowner of land measuring so-and-so, situated at village ward number so-and-so, Mendipathar, acquired for construction of new BG railway line from Dudhnoi to Mendipathar, East Garo Hills district, do hereby accept 80% of the total estimated costs of land compensation on so-and-so, which is payable to me as shown below, is fair, and I agree to accept the same without any protest. Now, all these people, my lord, in this area are...
This comes subsequent. This comes subsequent to the earlier.
Yes.
Definitely.
Yes.
11/8.
So,
and this is 38.
My lord, this was an undertaking I was made to sign. But being cautious, my lord will see this amount, total amount of compensation, they have shown as 1770,820. Amount paid on 30/8/2001 is 1416,656. But my lord, being cautious, although here they have said that I agree to accept the same without any protest, I have written, received under protest in terms of section 31(2) of the LA Act. So I have received that 80% amount, but under protest. Then my lord, of course, they also have disputed this Annexure 3, page 21. This was my application. I may not read this. This is my application for reference to the Special Judicial Officer. This is dated 28/9/11, but they've disputed this fact and said that this was received by me only on 17/10/2012. This is as per the affidavit in opposition. So when I heard nothing more from the collector, I filed this petition saying, please refer this matter to the Special Judicial Officer to ascertain, to fix the rate as claimed by me. Now, my lord, comes the interesting part. In their affidavit in opposition, in the affidavit in opposition filed by respondent number 2, my lord, has got the
How many affidavits are there?
My lord, I'll come first to affidavit in opposition filed on behalf of respondent number 2. That was dated
19/10/2019.
This is 19/8/2019. This was the first affidavit.
Yes, Tambe.
S. Tambe.
Yes.
My lord, we need not go to the entire thing. My lordship will just come to page 7, para 16.
Yes.
That with regard to the averments made in paragraph 15 of the writ petition, the answering deponent humbly states that the petitioner's reference application was dated 27/11/2012, was submitted to this office only on 7/12/2012, after more than 7 weeks, 50 days to be precise, from the date of the final award on 17/10/2012, and therefore could not be considered as same, was not filed within the stipulated period of 6 weeks. Now this is important. Their contention is that my application is time barred. And the final award was made on 17/10/2012. Now this is the only bone of contention. Now, subsequently by another affidavit. Now this carried on for I think nearly 4 or 5 years. Now subsequently by an additional affidavit, now the DC is saying that no, we are sorry, but the award was actually published on 14/11/2011.
It is much more before.
Much more before. Now this was with the additional affidavit filed by them.
Where is that?
That was filed only on 22/5/2023. 22/5, this is an additional affidavit.
Your written submission is there.
It's there. No, my lord. This, because after we file our written submissions, then we came with this. It is only after we file our written submissions.
This has to be modified then. Your submission has to be modified.
I will do some modifications. Well, my lord, this matter was fixed, I think, not less than 30 occasions, and the government could not produce the records.
That's the problem. It becomes more confusing, you know.
Yes. This was filed on 22/5/2023.
This is a reply to the additional affidavit. That's right. You
No,
filed
an
the-
additional affidavit in compliance. I have replied. My reply to additional the additional affidavit is on 22/5/2023.
Very difficult to remember. Sentence submissions.
So, in other words, my lord, in the affidavit in opposition filed originally, the contention of the government is that the award was on 17/10/2012. Whereas now they are saying that the award is in para 2 of the additional affidavit, they have stated that actually the land compensation was paid to Mrs. So-and-so an amount of 17, which I have showed your lordship, 17,70,820 as land compensation, which is reflected in the award statement dated William Nagar 14 November 2011. The petitioner herein is only the power of attorney holder of Srimati Marcella Momin. In fact, the said payment was made in two parts. Initially, 80% of the compensation award was paid on 30/8/2011, according to the government notification number so-and-so from the Revenue and Disaster Management Department, and subsequently the remaining 20% was also paid on 17/10/2012, which is also reflected at page 11 of the counter affidavit filed by the respondent number 2, that is the Deputy Commissioner, East Garhwal District. So initially, the case of the Deputy Commissioner was, the date of the award was 17/10/2012 as per Annexure 1, which is actually the statement of the amount received. It is not the award. So my argument earlier on also was that Annexure 1 is not an award. This is a calculation.
Okay. Just for
Yes,
for a
yes,
second.
yes.
Say supposing if you have received an amount which is assessed as initial payment of 80%. Now, will it not mean that there was an award in
Yes.
existence? Now, if we take, say supposing, of course the records will reveal whether it is correct or not.
Yes.
But then if we take that date prior to your receipt of 80%, then definitely what happens? Your application becomes time barred. Your application seeking reference, will it not be time barred?
No, it would not be time barred, because even at the time of receiving the 80%, I have said I am receiving this under protest. There's no need. Supreme Court has said there's no need of a formal application. Even,
Once it is under protest, it is automatic.
yes. So, for abundant precaution, even while receiving the 80%, I have said that I am receiving this under protest.
So once you say that, with your subsequent
So that
filing of
kept in notice.
application,
Yes.
basically
Yes.
it is of
It
no
is of
use.
all-
Basically, it has,
Yes.
it will not have much consequence
Yes.
over us.
Because they are already on notice that I'm not going to accept. Now, these are not important, my lord. These aspects. Let's say that it was on 2011. Now, what does the law say?
Now, what is your case about actually?
Yes,
Basically,
because they've refused. They have said
so
that
you are
reference.
seeking a referral.
That is not. That is a simple.
That is the case.
Now, notice, when it comes to notice, because Section 18, we'll have to come to Section 18 of the Act. In fact, before 18, it's 11. Before 18, we'll come to 11. Section 11 says inquiry and award by the collector.
Yes, here.
On the date so fixed or on any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objections, if any, which any person interested has stated pursuant to a notice given under Section 9 to the measurements made under Section 8 and into the value of land at the date of the publication of the notification under Section 4 and into the respective interests of the persons claiming the compensation, and shall make an award under his hand of the true area of the land, the compensation which in his opinion should be allowed for the land, and the apportionment of the said compensation among all persons known or believed to be interested in the land, of whom or whose claims he has information, whether or not they have respectively appeared before him, provided that no award shall be made by the collector under this subsection without the previous. This is not important, madam. So, number 18. Eighteen is important for this case, madam.
So section 11 is nothing. Is it like you're not?
Section 11 is the procedure for publication of award.
So you're not making any submission on section?
No.
11.
But basically, it's on 18. I'm sorry. 12. Before we come to 18, my lord, I'm very sorry. Section 12. Section 12 first. This speaks of notice. Award of collector when to be final. Such award shall be filed in the collector's office and shall, except as hereinafter provided, be final and conclusive evidence as between the collector and the persons interested, whether they have respectively appeared before the collector or not, of the true area and value of the land and the apportionment of the compensation amongst the persons interested. This is the most important aspect, Mullah. The collector shall give immediate notice of his award to such of the persons interested as are not present personally or by their representatives when the award is made. So this contemplates, subsection 2, that the award should be sent to all the persons interested. Just mere notice also is not enough, the Supreme Court has said. Notice must be sent along with the award to the persons interested.
It's then only to those who are not present.
Yes, those are not present. Then we come to 18, Malad, because the contention of the government is that under section 18, my claim is time barred. But as rightly been pointed out by my lord, even when receiving the 80%, I had already protested.
And that is okay. That is a query by you. I have not said anything.
No, my lord has
That's a
pointed
query.
out.
You see, I want to know it from you.
Yes.
Whether that would be enough. That will mean.
It is enough, my lord. Even oral. Shanti Devi case is very clear. Even an oral. Number 18, reference to court. Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for determination of the court. Whether his objection be
to any person who has not accepted the award, there is acceptance under protest.
Yes.
So that means he is not accepted the award.
Yes. But no, the time factor is there, man. Subpara 2, provided that every such application shall be made, because this is the stand of the government. If the person making it was present or represented before the collector at the time when he has made his award within 6 weeks from the date of the collector's award. So if you are present there, my lord, then your objection has to be filed within 6 weeks. Now, in other cases, within 6 weeks of the receipt of the notice from the collector under section 12, subsection 2, or within 6 months from the date of the collector's award, whichever period shall first expire.
Now you fall under which category? You fall under which category?
Under B. But B, my lord, what is the
So
interpretation?
it was, the notice was issued to you, 12-2.
No.
Then how do you come under?
Our case is that even no award was published. It was only later that they came with an award. My case is that I did not receive a copy of the award.
No, if no award was there, then how did you receive 80%? Is it not?
Yes, in fact, that is, they have to answer that. In the absence of award, how did you make 80%? How did you come to that figure?
But then once you receive some amount, can you now say that there was no award at all?
Yes, because what is the award? Now, that's why section 11.
That is a different issue. What is award? What is the actual award? You do not know.
Yes.
That is okay. But then can you say that there is no
I said,
award in
but now
existence?
they have come out with a copy of the award.
Now, you see, say supposing if there was no award, then what basis you have given your objection? Your objection, you receive it under protest.
No, because the collector has come to you collect this amount which is due to you, which is 80% of the award. So we went to the collector and said, okay, we're
The
receiving this.
confusion remains there. This is something. You see, once you accept some amount and you receive it under protest, saying that it is, see, this amount assessed is not appropriate. You see, as per the market value, it should be. And once you do it, you see, this is very much clear that something was there in existence. Otherwise, what? On what basis you will say? Your protest comes on what basis?
Because I have not received a notice as contemplated under 12.2.
But
12.2.
That is okay, but then
12.2 says that if upon the publication of the award, you must give me a copy of the award. Now,
it's okay. Say supposing if 12.2 is not complied with, then you come under 18 subclause 2b.
Yes.
No notice was served to you, but then within 6 months from the date of
Now
collector's
6
award.
months, how has the Supreme Court interpreted 6 months? Supreme Court has said that the 6 month period will be applicable from the date you have knowledge of the award. I said that no award was passed. They come up after.
So what about the very language of this provision then? Or within 6 months from the date of collector's award.
Yes.
It doesn't say about knowledge.
It doesn't say, but that's the interpretation by the Supreme Court in various cases.
Is it correct, Mr. Khan?
Yes. In various cases.
Is it correct?
Yes.
What senior counsel submitting about that? From which date you say, supposing if no notice was served under section 12.2 to any claimant. Okay. Now from which date you will count the period of 6 months?
Also,
the law says,
if you read 18A, 18.2A,
yes,
if a person making it was present
or represented
before the collector at the time when he made his award.
Now, see, this is one thing is that I think the petitioner was never present at the time when the award was made.
Absolutely, that situation is excluded.
Okay,
but
so
he was Lordship. If we come back to, we'll come back to 11.
Okay, Mr. Khan, sit down. Let Mr.
Please.
Let him finish.
Now, your Lordship will come to the judgment which I have annexed along with my written submissions.
Let us see where the written submission is. There is no judgment. Judgment is separately. So the thing, keep it with their written. That's really fun. This is the written submission is here. This is the written submission. No. Is this not the written submission? This is of the petitioner. Decision. So I think if it is kept together, it becomes easy.
My Lord has got a copy of the 2012-5 SCC 250.
Premji Nathu.
Premji Nathu.
Okay. Yes.
In fact, before this also there were many decisions. But I don't want to burden your Lordship with so many decisions.
No, give me just one.
No, this particular judgment has covered.
If I read more, I become more confused.
Yes. In fact, my Lord, that's why I want to concentrate on this. Para 12, my Lord, page 255, para 12.
Yes.
An analysis of the above reproduced provision shows that by virtue of section 12(1), an award made by the collector is treated as final and conclusive evidence of the true area and value of the land and apportionment of the compensation amongst the persons interested. In terms of section 12(2), the collector is required to give notice of his award to the interested persons who are not present either personally or through their representatives at the time of making of award. Section 18(1) provides for making a reference by the collector to the court for the determination of the amount of compensation. Section 18(2) lays down that an application for reference shall be made within 6 weeks from the date of the collector's award, if at the time of the making of the award, the person seeking reference was present or was represented before the collector. If the person is not present or is not represented before the collector, then the application for reference has to be made within 6 weeks of the receipt of notice under section 12(2), or within 6 months from the date of the collector's award, whichever period shall first expire.
That is what the provision says.
Yes. The reason for providing 6 months from the date of the award for making an application seeking reference, where the applicant did not receive a notice under section 12(2) of the Act, while providing only 6 weeks from the date of receipt of notice under section 12(2) of the Act, for making an application for reference, where the applicant has received a notice under section 12(2) of the Act is obvious. When a notice under section 12(2) of the Act is received, the landowner or persons interested is made aware of all the relevant particulars of the award, which enables him to decide whether he should seek reference or not. On the other hand, if he only comes to know that an award has been made, he would require further time to make inquiries or secure copies so that he can ascertain the relevant particulars of the award. What needs to be emphasized is that along with the notice issued under section 12(2) of the Act, the landowner who is not present or is not represented before the collector at the time of making of award should be supplied with a copy thereof so that he may effectively exercise his right under section 18(1) to seek a reference to court. In Harish Chandra Rai versus so-and-so, this court was called upon to decide whether the expression date of the award, this is important, is to be interpreted with reference to the time when the award is signed by the collector or from the date the affected party comes to know about the same and held as under. Therefore, if the award made by the collector is in law no more than an offer made on behalf of the government to the owner of the property, then the making of the award as properly understood must involve the communication of the offer to the party concerned. That is the normal requirement under the contract law, and its applicability to cases of award made under under the Act cannot be reasonably excluded. Thus, considered, the date of the award cannot be determined solely by reference to the time when the award is signed by the collector or delivered by him in his office. It must involve the consideration or the question as to when it was known to the party concerned, either actually or constructively. If that be the true position, then the literal mechanical construction of the words, the date of the award, occurring in a relevant section would not be appropriate. There is yet another point which leads to the same conclusion. If the award is treated as an administrative decision taken by the collector in the matter of the valuation of the property sought to be acquired, it is clear that the said decision ultimately affects the rights of the owner or the property, and in that sense, like all decisions which affect persons, it is essentially fair and just that the said decision should be communicated to the said party. The knowledge of the party affected by such a decision, either actual or constructive, is an essential element which must be satisfied before the decision can be brought into force. Thus, consider the making of the award cannot consist merely in the physical act of writing the award or signing it or even filing it in the office of the collector. It must involve the communication of the said award to the party concerned, either actually or constructively. My Lord, will come to para 18. There's a further clarification. Para 18. In Bhagavandas versus State of UP, this court interpret.
One minute. Just mark these paragraphs because I think it does not mark here.
Para 18.
Yes, please.
In Bhagavan Das versus State of UP, this court interpreted section 18 and laid down the following propositions. If the award is made in the presence of persons interested or his authorized representative, he has to make the application within 6 weeks from the date of the collector's award itself. If the award is not made in the presence of a person interested, he has to make the application seeking reference within 6 weeks of the receipt of the notice from the collector under section 12(2). If the person interested or his representative was not present when the award is made, and if he does not receive the notice under section 12(2) from the collector, he has to make an application within 6 months of the date on which he actually or constructively came to know about the contents of the award. Now this also is very clear, no?
Yeah, it's okay. Actually and constructively.
Yes. Well, Your Lordship had rightly pointed out, how was this 80% paid? Coming back to the... So this point is clear, Madam. Supreme Court has interpreted that it is the date of the knowledge. It is not the date of the award.
Then still, that provision
I know.
I do not know what happens.
I also, after much of research, when I came across these decisions, it says that it is the date of knowledge.
What would happen if there is a, you see, like a difference between what the actual act says and the proposition of law made with the appeals court says? If there is a conflict, then which way resolve it?
Your Lordship, then 141 will come into play of the Constitution. What the Supreme Court says is the law of the land. This court is bound by that, and we are bound by that. I know what is in Your Lordship's mind. The Act says otherwise, but the interpretation of that particular section is by the Supreme Court.
Can you continue after lunch? It's
Yes,
1:30 already.
Definitely.
We'll sit at 2:15 again.
2:15.
Your Lordship's intelligence.